Jamaica and WL Congo against the Secretary of State for the
My Lords, my Lady, I appear on behalf of the appellant WL with Mr. Vinsky, Mr. Hickman and Mr. Goodman, and on behalf of the appellant KM with Mr. Westgate, Queen's Counsel, and Mr. Goodman. My learned friends Mr. Beloff, Queen's Counsel, Mr. Tam, Queen's Counsel, Mr. Bourne and Mr. Johnson appear for the Secretary of State. My learned friends Mr. Ravinder Singh QC and Ms. Prahaska appear for the Intervenor Justice. My learned friends Mr. Ford and Queen's Counsel and Mr. Denham appear for the Intervenor Bail for Immigration Detainees. My Lords, my Lady, anonymity. Neither of my clients seek anonymity before this court, nor have they sought it in the courts below. So any contribution my clients make to the court's diet of alphabet soup, as my Lord Roger put it in the Ahmed case, is not of their own making. They were granted anonymity below, pursuant to the practice direction which provides for a presumption in favour of anonymity.
Well, does it follow we ought to lift any order for anonymity?
I'm neutral.
In their case?
I'm neutral.
I don't think it's totally straightforward.
It isn't totally straightforward, no.
We had this problem in SK, actually, and because I think...
So that's maybe Mr. Belloff.
I mean, I would personally, I'd like to know whether everybody's agreed about this before we made any pronouncement. Perhaps the Secretary of State would like to reflect on it before we... Because there's no urgency, I think.
Yes.
Just be reserved.
We'll reserve the position, so maintain the anonymity order protest.
Yes. I just want to make clear, my Lord, we're neutral on the issue.
Yes. Mr. Hussain, you will have to bear in mind that with the enormous number of documents, it's going to take us perhaps a little longer to identify anything to which we are referred.
I'm so sorry for the voluminous papers my Lords, my Lady have.
Yes.
If it is any consolation, I fear it will be very little consolation. We did try to fillet the authorities to some degree. You still have an enormous number of volumes. I am very sorry. My Lords, my Lady, the common appeals raise, in broad terms, the following four questions of law. First, the causation question. Is it open to the executive to extinguish liability in false imprisonment on the hypothesis that an individual could and would have been lawfully...
Well, Mr. Hussain, if you want us to write this down, you'll have to take it a lot slower than that.
I'm sorry. So the first question is a causation question. See, is it open to the executive to extinguish liability in false imprisonment on the hypothesis...
I'm so sorry. I wonder whether you could start again. It's just that I'd lost a document.
I'm sorry, Mike.
That is surprising. Could you...
So
Isn't there a simpler way of putting that question?
Is there a causation defence in,
Yes.
in the tort?
In false imprisonment?
Yes.
False imprisonment.
Yes.
Could you restate it for me?
My Lady, if I may...
Just finish.
Put it
Please
in this
do
way.
finish what you were going to say. I'm sorry, I didn't mean to interrupt you.
No, not at all, my Lady. Is it open to the executive to extinguish liability in false imprisonment on the hypothesis that an individual could and would have been lawfully confined in circumstances where, in fact, he wasn't? We say emphatically no. A causation test in false imprisonment is anathema to the common law and supported neither by principle nor precedent. It amounts to the creation of a special defence available to the executive in the tort of false imprisonment. Both Mr. Justice Davis and the Court of Appeal were wrong to endorse it. The simple point is that the tort is actionable per se without proof of damage.
Actionable per se what?
Without proof of damage. There's probably tautologists, my lord, there for emphasis. My lords, my lady, the second question, the publication question. Is it open to the executive to keep its detention policies secret? We say again that the common law, and certainly the convention jurisprudence, gives a firm no as the answer. Mr. Justice Davis was correct, and the Court of Appeal was wrong. Indeed, until the case reached this court, the Secretary of State had never argued to the contrary. The third question is the presumption question. Is it open to the executive to adopt a policy presuming in favour of an individual's detention under powers conferred by the Immigration Act 1971? Again, we say that any such policy would be contrary to the common law, the history of which is to presume in favour of liberty, as Mr. Justice Davis put it in paragraph 118. Such a presumption is also inconsistent with the convention jurisprudence. Again, Mr. Justice Davis was correct, and the Court of Appeal was wrong. The fourth question concerns damages, both basic and exemplary, and regrettably requires examination of whether the Secretary of State has discharged her duty of candour in these proceedings. Neither court got to the question of the basic award, given its conclusion on the causation issue, the first question, and both courts held that an exemplary award would not have been appropriate in any event. Both held that the duty of candour had been discharged. We respectfully submit that they were wrong on all counts. My lords, my lady, I have carriage of the first 3 questions of law, or rather our submissions on them. My learned friend, Mr. Westgate, will address you on the 4th, if that is acceptable to the court.
Yes.
Thank you.
Where does the Hardiel Singh, where do the Hardiel Singh points come into all of this?
My lord, these are the issues on the common appeals. Right. Yes. We say these common questions of law arise in a context which Mr. Justice Davis described as unedifying, disquieting at paragraph 1, and deplorable at paragraph 43.12. This was an understatement, as the Court of Appeal recognised at paragraph 6. There was, in the Court of Appeal's words, at a high level, a failure to have proper regard to, if not a disregard, of the legal obligations of the department. And that failure appeared not to be one of oversight. In other words, and this is not the Court of Appeal anymore, it appeared to have been deliberate. My lords, my lady, the courts were repeatedly misled over a 2-year period from April 2006 to June 2008 as to the true basis of the Secretary of State's decision-making. For those detained whose release was required by this Magna Carta rubbish as the policy lead of the Criminal Cases Directorate put it in August 2006, for those whose release was required by Magna Carta rubbish, it was said that the courts could take the hit. That is to say, the adverse publicity, in the words of the policy head of the agency itself. The approach was one of detain now, release later, if and only if compelled by the courts, and then blame it on them. It was an approach which we regretfully say had as a necessary consequence the undermining of public confidence in the judiciary.
Sorry, what was that?
A necessary consequence of the take the hit approach, which one finds, my lord, if you want the reference.
Oh, I see. Yeah, no. Yeah.
The necessary consequence of it was to undermine confidence in the judiciary. The approach was, it appears, authorised at ministerial level as the preferred position, as the policy head put it in July 2006.
There was a change of Secretary of State at the beginning of the period, was there? I think that's right. I think Mr. Clark went.
The reference to the preferred position is a reference to Mr. Reed's, Dr. Reed's.
Dr. Reed.
I mean, the balloon went up in April 06, did it not? And Mr. Charles Clark was the incumbent Secretary of State, lost his position, and Dr. Reed came in.
Indeed, my lord. My lords, my lady, we say that the preferred position of permitting the courts to take the hit, of keeping the true basis of decision-making from the courts for such a long period, was corrosive of the trust which the courts place in the executive to be frank and to adopt a cards-up approach. The Secretary of State's cards here were not just kept close to the chest, they were hidden under the table. The courts were seen as antagonists rather than partners with whom the Secretary of State was to cooperate, in Lord Donaldson's words in Huddleston, and to whom a duty of candour was owed. My lords, my lady, this is why we say that the issues arising in the context they do go to the heart of the rule of law. The law, of course, protects, with, if anything, all the more jealousy, the rights of the unpopular and the marginalised, even the undeserving, as my clients may on one view be seen to be. That theirs were cases which presented, in the view of the Director of the Criminal Cases Directorate, a favourable, and I'm quoting here, a favourable factual backdrop to disclose Cullen, one of the hidden policies, that they presented a favourable factual backdrop to disclose Cullen in a low-key way within the broader evidence, rather than in some unspecified further case where the facts may not be so much in the agency's favour, should not matter to the disposal of the issues, even if the court agrees with that executive view. One final aspect, my lord, my lady, of the context deserves emphasis, we say. The United Kingdom will shortly be the only member state of the European Union that detains immigrants for removal without limit of time. My client, WL, has been in administrative detention for 53 months. He is, on any view, seriously mentally unwell. That puts into acute focus the need for robust safeguards, both administrative and judicial. Yet the Secretary of State contends that her detention policies don't need to be published because it would be inconvenient to do so, that the executive can presume to detain, and that even with that latitude, where the decision to detain is unlawful, there should be no liability in tort, and the Secretary of State should be insulated from the ordinary consequences of her error. Finally, my lords, my lady, if there is a linking theme, we say, between the common appeals and WL's appeal, where the Hardiel Singh issues arise, it lies in the Secretary of State's claim for a diminution of the legal safeguards applicable to her broad detention power.
Could you say that again? I'm sorry.
We say if there is a linking theme, my lord, between the common appeals and WL's individual appeal, it lies in the claim made by the Secretary of State, we say, for a weakening, a diminution of the legal safeguards applicable to her broad detention powers.
Claim for diminution of what?
Legal safeguards.
Of the legal safeguards applicable to the broad detention power she has. So, by way of example, she contends on WL's appeal that time spent in detention pending appeal, regardless of the merits of the appeal, falls out of account in assessing whether detention has become unduly protracted. She says that where an individual could voluntarily return, his detention is to be seen as self-induced, even though the premise of the detention power is an enforced removal. And finally, by way of example, she says that it was perfectly proper for the Court of Appeal, deciding the legality of WL's detention in February 2010, to focus its consideration on the position 19 months earlier, in July 2008, the position before Mr. Justice Collins. Now, my Lords, I'll return, if I may, to WL's case, and if I may open it separately in due course. But I would now like to develop my submissions on the issues in the common cases, if I may. Can I first of all very briefly take my Lords, my Lady, to the statute, please? It's at volume 1, tab 1. This is, of course, the Immigration Act 1971.
As amended?
As amended, my Lord, it's up to date. And for present purposes, my Lords, my Lady, all we have to go to is, first of all, page 6, if you look at the top right pagination. This is section 3, General Provisions for Regulation and Control. At the bottom of the page, a person who is not a British citizen is liable to deportation from the United Kingdom if A, the Secretary of State deems his deportation to be conducive to the public good, or B, another person to whose family he belongs or has been ordered to be deported. Both my clients were subject to deportation proceedings pursuant to Section 3.5a. 3.6 provides for what are called court recommendation cases. So without prejudice to the operation of subsection 5 above, a person who is not a British citizen shall also be liable to deportation from the United Kingdom if, after he has attained the age of 17, he is convicted of an offence for which he is punishable with imprisonment, and on his conviction is recommended for deportation by a court empowered by this Act to do so. My Lords, at page 15, top right pagination, so that's the first stage of the deportation process. What the Act has always provided for is an appeal against that decision. It's now in a different Act. It used to be in Section 15 of this Act. The next stage of the deportation process, if the appeal is unsuccessful, as it was in both these cases, is proceeding to make a deportation order. And one has that in Section 5. The power to make the order is in Section 5, page 15. Section 5, procedure for further provisions to deportation, where a person is under Section 3.5 or 6 above liable to deportation, and subject to the following provisions of this Act, the Secretary of State may make a deportation order against him. That is to say, an order requiring him to leave and prohibiting him from entering the United Kingdom, and a deportation order against a person shall invalidate any leave to enter or remain in the United Kingdom given to him, given him before the order is made or while it is in force. Section 5.5 provides that Schedule 3 shall have effect with respect to removal. One finds Schedule 3, my Lords, my Lady, at page 49 of the extract. And strangely, after that, pagination disappears. We need to go to the next page. And these are the critical provisions.
In paragraph 2.
Paragraph 2, my Lord, yes. Detention or control pending deportation. So 2.1, this speaks to the Section 3.6 court recommended deportation power. So 2.1, where a recommendation for deportation made by a court is in force in respect of any person, that person isn't detained in pursuance of the sentence or of the court, he shall, unless the court by which the recommendation is made otherwise directs, or a direction is given under paragraph 1A below, that's the criminal appellate court directing release, he shall be detained pending the making of a deportation order in pursuance of the recommendation, unless the Secretary of State directs him to be released pending further consideration of his case, or he is released on bail. And then 2.2, this speaks to the detention power at the first stage, in between the first and second stages of the deportation process. So after a decision has been made under section 3.5, or 3.5, that a person is to be deported, they may be detained under this power. So where notice has been given to a person in accordance with regulations under section 105 of the Nationality, Immigration and Asylum Act 2002, notice of decision, of a decision to make a deportation order against him, and he is not detained in pursuance of the sentence or order of a court, he may be detained under the authority of the Secretary of State pending the making of the deportation order. And then 2.3, my lords, my lady, deals with the position once a deportation order has been made. So where a deportation order is in force against any person, he may be detained under the authority of the Secretary of State pending his removal or departure from the United Kingdom, and if already detained by virtue of subparagraph 1 or 2 above, when the order is made, shall continue to be detained unless he is released on bail or the Secretary of State directs otherwise. My clients were detained under paragraph 2.2 and 2.3. The notice of intention to deport, KM, was given in early May of 2006.
10th of May.
A slight confusion. The letter is dated the 9th of May 2006. You have that at Appendix Part 4, page 2901, and that was what Mr. Justice Davis found in the SFI. An agreed fact is that it was on the 10th of May 2006. I don't think it matters at all. The deportation order was signed in respect of KM on the 15th of December 2006 and served on him on the 20th of December 2006. That's the Statement of Facts and Issues, paragraph 53. In WL's case, the notice of intention to deport was given to him on the 3rd of April 2006, and that is Appendix 3B, page 2353. The deportation order was signed against him on the 14th of March 2007. That's Statement of Facts and Issues, paragraph 10. Now, my lords, at paragraph 2.4a, you see that paragraphs 22 to 25 of Schedule 2 are applied to this schedule. Those paragraphs, importantly, include provision for bail to be granted and then, my lords, my lady, at paragraph 5, there is provision for a person to whom the subparagraph applies to be subject to such restrictions as to residence, as to his employment or occupation, and as to reporting to the police or an immigration officer, as may be from time to time notified to him in writing by the Secretary of State. and the person to whom the paragraph applies is defined in subparagraph 6, a person liable to be detained under paragraphs 1, 2 or 3 above, with certain savings. And effect of appeals, my lords, my lady, at paragraph 3 of Schedule 3 at the bottom of the page, that applies further bail provisions in Schedule 2 to Schedule 3. And I just want to go to one of them, if I may, just now, and that is the paragraph 30 of Schedule 2, which you have at page 43. Paragraph 29, I should say, provides for the grant of bail pending appeal. Criteria aren't set out. 29.3 indicates that the first-tier tribunal may release an appellant, etc. Similarly, 29.2 provides for a similar power in the immigration officer. And then the restrictions on the grant of bail are set out at paragraph 30 over the page. This is page 43. An appellant shall not be released under paragraph 29 above without the consent of the Secretary of State, etc. There's case law to the effect that such consent can't unreasonably be withheld, as unsurprisingly. And then subparagraph 2, notwithstanding paragraphs 2, 3 or 4 above, 4's been deleted, that the tribunal shall not be obliged to release an appellant unless the appellant enters into a proper reconnaissance with sufficient satisfactory sureties if required, or in Scotland sufficient and satisfactory bail is found, so required, and the tribunal shall not be obliged to release an appellant if it appears to the tribunal. And then 5 bases for not granting bail are set out, but what we would underscore is the idea that where these grounds for refusing bail exist, the tribunal is no longer obliged to release the individual. And we say that provision has certain consequences for the argument.
I mean, did 29.4 talk about obliging them? Because otherwise one doesn't see where it came from.
My lords, I'll have to check that. Another part of the context is, in fact, that in the Act which applied this paragraph to Schedule 3 had also enacted a system of automatic bail hearings. My lords, my lady, you may recall that from the SK case in February this year. You were taken to it. But there was a system of automatic bail hearings in Section 44 of the 99 Act, which provided for a presumption of bail in unequivocal terms. That regime was never brought into force, and it was eventually abolished in February 2003 by the 2002 Act, Section 68(6)(3).
But I mean, you see what I mean.
We'll check that. Well, I do see what you mean, my lord, of course, yes. I took you to that provision, my lords, my lady, because of its importance, we say, for the third question, the presumption question. My Lords, my Lady, you have in your bundles many policy documents. I'm not going to take you to them. It suffices to say that since 1991, the Secretary of State has had a policy presuming in favour of liberty. So in 1991 and 1994, you have the documents at volume 2, tab 11, the Immigration Service instructions authorised detention only where there was no alternative. In 1998, the white paper, Firmer, Faster, Fairer, provided for a presumption in favour of liberty. You have that at 212, volume 2, tab 12. At 12.20, the white paper stated that the government was mindful that the deprivation of liberty is a grave step which must only be used with great care and when no alternative ways of ensuring compliance are likely to be effective. The white paper in 2002, which you have at 214, restated that presumption at 4.76. And then the manuals, which my Lords will have looked at in cases before them, the Operations Enforcement Manual, that was the manual in Nadaraja, for example, that the Court of Appeal looked at. You have that from April 06 at volume 2, 17, where again the presumption is stated at 38.3. There must be strong grounds for believing that a person will not comply with conditions of temporary admission for detention to be justified. You have in the next tab the same manual, that's volume 2, tab 18, dated March 2008, almost 2 years into the adoption and application of the hidden policy. The manual is unchanged. And then at tab 219...
Have you got a paragraph number for that?
It's the same paragraph, 38.3, it's unchanged. And at 219, volume 2, tab 19, you have dated April 2008, chapter 55 of the Enforcement Instructions and Guidance, and this, my Lords, my Lady, was exhibited to the first statement of Hannah Honeyman, which you have at Appendix Part 3A, page 2254, in the WL case. Again, the presumption in favour of detention, in favour of liberty, that's an unfortunate slip of the tongue, was stated. And that was explicitly stated at 55.5, page 203 of the extract in that tab, if my Lord's interested in...
I'm sorry, give that citation again, please.
It's paragraph 55.5. At page 203 bottom right pagination.
Yeah, thank you very much.
And also in the opening paragraph at page 200. And that was the statement exhibited to Miss Honeyman's witness statement. Sorry, this was the policy document exhibited to Miss Honeyman's witness statement in the WL case. 3A, page 2254.
Mr. Hussain, what relationship do these documents bear to what the Home Secretary of the day said to Parliament his position was? Or put the other way around, what relation does what he says to Parliament have to what is in these documents?
Well, it's common ground that what he said and the practice that emerged and the policy that was adopted by November 2007 was inconsistent with these policies. That's common ground.
Yes, well, I understand that. But if I were an MP or somebody who read Hansard and so on, what would I think the policy of the Secretary of State on this matter was?
Well, you'd listen to the statements made in the House, and then you'd look on the Home Office website, and you'd see...
Well, just supposing I didn't look on the website, what would I think that the Home Office policy on this matter was? To judge by what the Home Secretary said to Parliament.
Well, you would think that there was a strong...
that these people ought to be kept in detention until we have fully considered their deportation, which
Yes.
is what he said.
Yes, which obviously speaks to the first period only.
I'm just trying to understand.
Yes.
What is it? I mean, does that have a bearing on this issue? What he says to Parliament?
Look, it doesn't have any bearing at all on the issue before you, because it is not argued by my learned friends that there was sufficient publication. That's not argued. It's not their case.
I'm just trying to understand.
Mr. Tan sought to argue before Mr. Justice Davis that there was sufficient publication through a variety of media, and that was rejected.
All I'm trying to understand, does what the Home Secretary say to Parliament, is that an expression of policy or is it not?
It's capable of being, yes.
But in this case?
Well, we say that it precisely was an expression of policy. What was going on was that absolutely everybody was being detained. We say that everyone was being detained. And the Court of Appeal found that, at least as from November 2007. There was a blanket policy of detention, or rather a policy of detention that was unlawful on any view because it did not permit Hardyal Singh release. The people who were released were people who were very ill, pregnant women, people like that. So when the Home Secretary herself said to the Prime Minister, we have a near blanket ban on release, a document that was disclosed to us on Friday evening at 8 p.m. before the Court of Appeal hearing, that's what she was talking about. A document whose existence the Secretary of State or her advisors, or I don't want to point fingers, were aware of before Mr. Justice Davis, but which was not disclosed to him. Mr. Westgate will address you on those matters. My Lords, unfortunately, there is an error in the bundles. The September 08 policy is the next policy in time, and it's the next tab. I don't know if you'd like me to give it to you now, or we can arrange for copies to be handed up later.
Is this tab 20?
My Lord, yes. Do you have it?
Well,
Yes, that's wrong.
it doesn't look right to me.
No, it's wrong. Would you like it handed up now, my Lords? Or I can do it later.
Well, if we're taking this in chronological order, it probably would be helpful to have it, wouldn't it?
Certainly. Alan. I'm so sorry.
This is September 2008.
This should slot in instead of tab 20, is that right?
Yes, please, my Lord.
Yes.
What is it?
This is the hidden policy belatedly being published. It's chapter. It's the same. Has the same name. It's chapter 55 of the Enforcement Instructions and Guidance, but it's dated. Although I don't think the date is there on the document, but it dates from September 08.
This is narrated in the Court of Appeal's judgment in paragraph 19. Is it,
My Lord, yes.
I got the correct.
Sorry, yes. Sorry, this was. I'm reminded, not the policy, not the hidden policy made public, because the Court of Appeal found that from November 07 onwards there was a near blanket policy. This is a presumptive detention policy, and you see that at 55.1.2.
Would normally be detained.
Exactly, Madam. So this was before Mr. Justice Davis, when he heard the case in November 2008. And the issue of presumption, the third question, is relevant because in WL's case, he continued to be detained pursuant to this policy. Previously, it is important to underline that as from November 07, at the very least, there was what we call a blanket policy of detention, or a Hardial Singh incompatible policy of detention. And it's important to underline that because we regret to say that in her printed case, the Secretary of State repeatedly talks about the secret policy as being one of presumptive detention. Well, that's okay if it's meant irrebuttably presumptive detention. But I don't think that is what is meant in the Secretary of State's printed case. The position is, on the Court of Appeal's findings, which are not the subject of challenge by the Secretary of State, that as from November 07 by the latest, there was a blanket policy of detention or a Hardial Singh incompatible policy of detention. September 08, there was a published policy presuming in favour of detention.
For FNPs?
My Lord, yes. Sorry, I should say...
Yes, because the policy document begins with the contrary policy.
Yes. This is solely for FNPs. It's for the people who have provoked the furore.
But are you saying that this, in September 2008, displaced the hidden policy or simply a different public policy which nonetheless concealed the blanket policy that was in place before.
We have never said that it displaced it.
The blanket policy remained the practical policy. This was not, or not.
No. We don't say that. So, sorry, this did displace it. Yes,
It did displace
I'm sorry, my lord.
Yes, right.
I'm tracing this through the Court of Appeal as you're going through this material. Paragraph 20 summarises it very briefly. Do you accept what is said there? This is paragraph 20 in the Court of Appeal judgment. The published policy had changed.
Well, that's clear. Yes.
Until that date, I take it, the published policy was in favour of release.
Yes.
But after this, because this is now published, you got the express presumption in favour of detention.
Yes. That is correct. So, my lord, tab 21 in the next tab is the policy as at August 2010. I think the current policy, and that you'll see how it's put. This was the policy that was changed after Mr. Justice Davis's judgment in January 2009, and it's the policy to which the Court of Appeal makes reference in the final sentence at paragraph 20 of its judgment.
Yes.
And you'll see how it's put, my lords, my lady. At 55.1.2, so cases concerning FNPs are subject to the general policy set out above. That's a presumption in favour of temporary admission or release. The starting point in these cases remains that the person should be released on temporary admission or release unless the circumstances of the case require use of detention. However, the nature of these cases means that special attention must be paid to their individual circumstances in any case in which the criteria for considering deportation action, the deportation criteria, are met. The risk of reoffending and the particular risk of absconding should be weighed against the presumption in favour of temporary admission or temporary release. It's usually a clear imperative to protect the public from harm from a person whose criminal record is sufficiently serious to satisfy the deportation criteria, and or because of the likely consequences of such a criminal record, for the assessment of risk that a person will abscond. In many cases, this is likely to result in the conclusion that the person should be detained, provided detention is and continues to be lawful. However, any such conclusion can be reached only if the presumption of temporary admission or release is displaced after an assessment of the need to detain in the light of the risk of reoffending and or the risk of absconding. And we say that is the policy that was brought in after Mr. Justice Davis' judgment and is a lawful policy. It has its starting point, release. And I won't take you to two other passages. I'll just give you references for them if that is helpful. The other passages are 55.1.3 under the heading CCD cases, and then also 55.3A. Also 55.3.2.1. It's the same idea.
55.3. Sorry, yes. Yes, I see. Yes.
So what are the additional references in that document?
Sorry, the additional references, my lord, are 55.1.3, 55.3A, 55.3.2. That's it. Now, my Lords, may I at last turn to the causation issue? And I begin with it because the issue may properly be regarded as the key issue in the joint appeals, because it is common ground that the hidden detention policy adopted by the Secretary of State was unlawful because, A, it was adversely inconsistent with the published policy, and secondly...
Sorry, can you do a little bit more there? First, it was inconsistent with what?
With the published policy.
Did you not mention the word adverse?
Adversely inconsistent with. There wouldn't be a problem if it was beneficially inconsistent.
And then you said secondly something?
Secondly, I should just say that is the Court of Appeal's finding. Mr. Justice Davis found an additional basis upon which the policy was lawful. He said it was unlawful because it hadn't been published, simpliciter. The Court of Appeal said, no, it's fine not to publish your detention policies. That was not the subject of an appeal by the Secretary of State. It was a finding that the Court of Appeal made of its own volition, without hearing any argument at all. And it found that the illegality lay in the inconsistency between the hidden policy and the published policy. But secondly, I hope it's common ground, certainly ought to be, that at least from November 07 onwards, the policy was one of blanket detention. That is what the Court of Appeal found at paragraph 45, page 26 of Appendix Part A, Core Volume 2. And the Secretary of State has always accepted that a blanket detention policy could not be lawful. It would either be a fetter or it would be inconsistent with Hardiel Singh, if that's what it was. And the Court of Appeal found that it was that.
Fetter or what?
A fetter or inconsistent, my Lord, with Hardiel Singh criteria. The idea, my Lord, in broad terms, obviously, is that you have a statutory power. Whether you regard Hardiel Singh as going to the existence of the power or the exercise of it, your policy's got to be within those limitations. And at the very least, from November 07 onwards, it was not within those limitations. People were being detained who, on Hardiel Singh grounds, had claims to be released. So, my lords, my lady, there is no dispute about the fact of illegality. The dispute is only about the extent and nature of it. So, first of all, was it also unlawful because it wasn't published? Was there a blanket detention policy even before November 07? And Mr. Westgate will address you on that. Unusually, we say, obviously the court is very, very loath to revisit any finding of fact by the lower court, but we have had disclosure in the weeks leading up to the hearing. November seems to be a magic month. We had 5 volumes of disclosure in November last year, before the Court of Appeal hearing, and disclosure before Mr. Justice Davis, just before the hearing in 2008. And you've had it filleted down, my lords, in Appendix Part 5. And then the final dispute about the extent of legality is whether or not, even when the policy was published, when it did displace, we accept the secret policy, when it was published in September 08, whether it was unlawful because it presumed in favour of detention. So, my lords, my lady, our case on the issue of causation...
Sorry, you said a moment ago when the secret policy was published. When the policy was published
When policy was
that
published,
was
sorry.
presumptive, was it
Presumptive.
nonetheless?
My Lord's absolutely right.
Yes.
I made a slip. I'm sorry. Our case our case on causation rests upon a rigorous application of well-established doctrines. That is what Mr. Beloff says. It's not what I say, it's what Mr. Beloff says at paragraph 7.1 of his case. And he is correct. It does rest on a rigorous application of established doctrine, and we are right to insist on a rigorous application of principle, because it was, of course, my Lord Hope who said in the Evans case that the defence of justification, in the tort of false imprisonment, of course, must be based upon a rigorous application of the principle that the liberty of the subject can be interfered with only upon grounds which a court will uphold as lawful.
I think, to be fair to Mr. Beloff, he says that your case is a rigorous application of the dicta in Holgate Mohammed,
No,
which is rather different. The 7.1, that's what it says.
Of two, well, it's Anis Minute and Holgate Mohammed, my Lord, he says. He said, my Lord's right, it's based on two legal doctrines. Each is well established, each involves a legal fiction. First, the ultra vires doctrine. It is rather well established. And then the Holgate Mohammed doctrine, which we say is simply an application of the Anis Minute doctrine. Nothing more, nothing less. The Evans quotation is from page 35, E to F, of Evans at volume 11, tab 110. My Lord Hope referred to liberty of the subject. For liberty of the subject, we read liberty of one subject to the jurisdiction, because the Secretary of State rightly accepts at the outset that there is no different law for aliens. See our case at paragraphs 7 to 16, and the Secretary of State's case accepting those paragraphs as correctly setting out the law at paragraph 3.1.
I mean, you need a bit more than Evans, don't you? Because, I mean, Evans was, there it is, a court sentence on proper calculation, entitled to be released on one day, held because of miscalculation to a later date. No defence.
Well, but the reason I cite Evans is because of what Lord Hope says about it.
But I'm saying you need more than that
of course.
for this case.
Of course, and we have it. We have Anis Minute, and we have the basic proposition that the tort is actionable per se. My Lord Roger put to me that all that Evans decided in the SK case in February, that all the Evans case decided was that the tort was one of strict liability. And we say that tells you a lot. It tells you where the law focuses and how it balances competing claims and competing interests. So I'll come on to that in due course. But, my Lords, can I just clear three things out of the way? The first is that, contrary to the Secretary of State's suggestion, repeated suggestion, at paragraphs 1.2, 3.2 and 7.4 of her case, we do not say that trivial or minor errors vitiate a detention authority any more than they do a public law decision.
Vitiate what?
A detention authority, a decision to detain somebody. Any more than they vitiate any public law decision.
How do we know if they're trivial or minor?
Well, an example I gave in the SK case, again, is in response to a question by my Lord Hope, was that a failure to sign a detention review, where that wasn't required by the statute, would be a trivial or de minimis error.
But your point is, anyway, although there may be difficulties at the margins,
Yes.
Those are difficulties which are inherent in any public law challenge to a
Yes.
decision.
Yes.
And they're the sort of challenges, they're the sort of problems that the administrative court has to grapple with when they're raised.
My Lord, absolutely. We say wherever you draw the line between trivial and non-trivial, we are miles away from that line because the policy wasn't simply relevant to the decision, it was controlling of it and intended to be controlling of it. Each of the policy documents to which I referred says in terms that in order to be lawful, detention must also be in accordance with the government's stated policy on the use of detention. Now, that obviously doesn't mean that that's the law. That would be constitutionally subversive to suggest that the policy could itself set up what was the law and what wasn't. But what it does tell you is that the policy is intended to be controlling. It's not simply a relevant consideration for the decision maker to take into account with other things. It's supposed to be dispositive of that decision, at least presumptively dispositive. I say presumptively because there may be good reason not to follow the policy. But this was not a trivial error. And even if one simply posits the illegality as the inconsistent application, the application of a policy adversely inconsistent with the published one, then that is a major error. If one extrapolates from paragraph 45 of the Court of Appeal, and one sees that the detention policy was near blanket, well, that is a seriously major error, a fettering of discretion. But whichever way one looks at it, this was an important, non-trivial, non-minor error. Now, what the Secretary of State says is that this major and important error, as we put it, shouldn't vitiate the detention authority if a judicial review court, administrative court, in exercise of its discretion, would not grant relief on the no difference basis, on the no difference principle. And I will come on to that in due course. But my lords, my lady, the second point I want to clear out of the way, it may not be helpful, in which case I apologise in advance, and that is that we don't say that all important errors relating to detention decisions render the detention unlawful. So, most obviously, an error as to conditions of detention doesn't render the detention unlawful. That is, of course, the Hague case in the House of Lords, and you have Hague at volume 8, tab 76, a failure to provide timely access to a solicitor after the individual has been detained, even when that's required by the statute, as it was in the Cullen case from Northern Ireland. Cullen, my lord, that won't render the detention unlawful. And Cullen, my lords, my lady, is at volume 13, tab 127.
What was the previous reference, please?
The previous reference was to Hague,
Yes.
and it was 876.
Thank you. Yeah.
The legal failure must bear on the decision to detain. And in the SK case, there was much argument about whether or not a failure to conduct a review, as expressly required by the policy, is impliedly required by the detention centre rule, subordinate legislation, whether that vitiated the detention authority. SK relied on Roberts to say it would. It was effectively a condition subsequent to detention, the legality of detention. The Secretary of State contested that. Here, no such issue arises. It is very obvious that the error as to the policy bore directly on the decision to initiate and to continue detention. And the Secretary of State doesn't suggest otherwise. And my lords and my lady, the third thing I want to clear out of the way is that we do accept that the mere existence of an unlawful detention policy would not render a decision to detain unlawful if that decision, in fact, wasn't influenced by it. But that isn't remotely a question. That's not at all a question of causation. That's not remotely a question of causation, as Mr. Belloff would have it with respect. The issue is simply, was the policy applied? Not, did it make a difference to the outcome?
Sorry, the issue is what? How do you say not a question of causation? I didn't hear.
The issue is, was the policy applied? We accept, my lord, that if you have a detention policy that is unlawful, but the relevant decision maker is ignorant of it or is not applying it in the individual case, the policy may be intended to be applied to everyone. But in the individual case, the decision maker is proceeding lawfully. He or she is not relying on the detention policy. We say, of course, that doesn't vitiate the decision. But that is not the same thing as saying that where it is applied, it's perfectly fine if in the end it wouldn't have made a difference.
Just assume you've got a multiple rapist and reaches the end of his sentence, FNP. I mean, nobody in there, it's intended to deport him. Nobody in their right mind would not detain him. This unlawful policy is in existence. That's unlawful detention from then on?
If it's applied in his case, my
well, when you
yes.
say if it's applied, that's what I'm wondering. I mean, you know,
if it informs the decision.
Well, does it in a case like that, where the decider says, well, here it is, this chap's not, on no possible basis would you free this person?
Well, my lord, it isn't open season simply because you've got an unmeritorious individual. It's not open season. The decision maker can't just say, oh, well, it doesn't matter what policies there are, I'm just going to detain this man. I mean, there has to be a process. He's got to apply his mind to the correct process. And if the decision to detain is informed by an unlawful rubric, an unlawful framework, an unlawful policy, then that, we do say, vitiates the detention authority. It is a grave matter to administratively deprive someone of their liberty. A very grave matter, as the government accepted.
Your phrase, if the decision is informed by, yes, is a rather vague phrase, isn't it? Are you saying if it is a relevant factor or if it is the determinant factor in the decision?
Well, my lords, in these decisions, the policy is only ever a determinant factor. Nobody is going around, as we understand it, with some sort of residual discretion, residual power outside the policy, yeah, and taking decisions outside them. The policy says you have to conform. You, my officials, have to conform with this policy. It is controlling of that discretion. And therefore, we say, the concession I'm making is I hope, quite prosaic.
Yes.
If you have this policy and a decision maker isn't aware of it, or for whatever reason one can imagine circumstances thinks that it's a terrible thing and it proceeds to apply a lawful policy, yeah, then the unlawfulness has not infected the decision.
Yes.
Well,
but the focus that you're drawing attention to is on the decision. Yes. There's quite another question. Was the decision the cause of the detention? And that raises the argument, well, the detention would have occurred regardless of, yes, the motivation for the decision.
Yes, but there is a movement between those two propositions. And it's important to remember that because the Secretary of State, for obvious forensic reasons, fuses that movement. He says it's just a short step. You just move seamlessly from the one to the other. Absolutely not, we say. There is a causation element in the tort. It only speaks to the question of who is responsible for the detention. That's the Davidson case, it's the Iqbal case, the store detective case, the prison strike case that Mr. Beloff was involved in. The question is, are you responsible for the detention of somebody where you don't actually turn the key in the lock? Have you set a ministerial officer in motion? The test is, does the third party who actually does turn the key in the lock, do they exercise any independent discretion? That's how the causation element works. And it's actually a very tight causal element because you've got to have directness. And that is what differentiates this tort and the trespassory torts from other damage-based torts. And it's what, at a conceptual level, the Court of Appeal, with great respect, failed to grasp.
I mean, I don't understand why, logically, every FNP who was detained during the period of the unlawful, unpublished policy wasn't unlawfully detained on this approach. You say he probably, you say he was, you?
Oh, yes.
Every FNP detained during the period of the unpublished unlawful policy has a claim in false imprisonment.
If the policy was applied to their cases.
Well, you say if it was applied, but I don't understand. Well, what scenario would it not be applied? Unless you say you could actually produce a decision maker who said, well, I knew this was the policy, but I regarded it as unlawful and didn't apply it. I mean, so for that case.
My Lord, the reason I'm spending some time on this is because there were some rather equivocal findings, if I may say so, in the Court of Appeal on this question of whether or not the unlawful policy was applied to the detention of these two individuals. We have said there is an incontrovertible case it was that the Court of Appeal's findings on the point were equivocal, and the Secretary of State has nowhere joined issue with that. We've set it out.
What's the answer to Lord Brown's question?
If applied, yes. Every FNP would have a claim in false imprisonment if an unlawful policy was applied to the decision to detain them.
But I thought his question was how could you, in these circumstances, distinguish between a case where it was applied and not applied?
I'm sorry, I've misunderstood. Well, you were... It's an odd question. I don't mean that remotely pejoratively, of course, my lord. It's an odd question because one would think that if you have a controlling policy, it's going to be applied. But there were some equivocal findings in the courts below as to whether or not, in these cases, this unlawful policy was applied or not. And the Secretary of State, despite the fact that the Secretary of State herself accepted in WL's case that they were, and Mr. Beloff doesn't join issue. Perhaps I can move seamlessly on from this issue and come back to it if Mr. Beloff makes any point out of it in his response to these submissions.
Does the system of review have anything to do with this?
I'm sorry?
Does the system of review have anything to do with this? Because you could have initial detention, which on any view was entirely justified. And then there's a question, time slips by, no attention is paid to the fact that the person is still in detention. No, is it because there is, or was understood to be, a system of review that one would reach a stage at which you would say, well, a decision is now being taken which is dictated by the unpublished policy?
Well, there is another magic date in these cases, which is February 07. There are no reviews undertaken before February 07. No one is paying the slightest interest to these people who were detained. It happened in the SK case. His first review was in February 07. It's what happened in KM's case. It's what happens in WL's case. So for that period of time, there are no reviews, which we say is suggestive of a blanket detention policy. And we say that at the very least, my lord, you are right. The decisions to continue detention, if not initially to authorise them, were taken in these cases by reference to an unlawful secret policy. But the answer to my Lord Brown's question is there may be, how can I put it? The decision maker may get lucky, in a sense, by applying a lawful framework, even though the dominating framework is unlawful. As I said, this issue is addressed in our case at paragraphs 133 to 137 and Annex A. But as I said, I think it's best if I wait and see what Mr. Beloff says about this, because he doesn't join issue with what we say there. Can I then move on, my lords, to the problem as the Secretary of State sees it? She complains about the undesirable results if any public law error in the decision to detain is vitiating. That's 10.16. She says the fundamental issue is one of appropriate remedy. At 3.4, it is said that the remedy of damages in false imprisonment is disproportionate and oversized sledgehammer, where the vitiating error may be relatively small. And that's at her case 7.22 and 7.24. We say, she also says that it is a blunt tool at 6.8. We say that the tort is a constitutional protection to the right to liberty, and we are supported in that submission by Lord Hobhouse in the Evans case at volume 10, tab 110, page 43, F to G. We are also supported by Dicey, which we cite at page 17 of our case, footnote 12. The relevant extract is at volume 30, tab 295. Dicey, in the 8th edition, the last edition he wrote himself, applied his general analysis of the rule of law in chapter 4 of his book to personal liberty in chapter 5. He gave separate treatment to redress for arrest, that is to say, by punishment or obtaining, I'm quoting, compensation for the damage inflicted in criminal law or trespass. And then he moved on to habeas corpus. It's clear he saw both remedies as fundamental and constitutional protections integral to the rule of law.
So could you just give me the reference to Lord Hobhouse again?
Lord Hobhouse, my Lord Evans, 110, page 43, F to G.
It's 11, in fact.
Volume 11, 110.
Did I get that wrong? I'm so sorry, my Lord.
Yeah,
I think it must be volume
Volume
11.
11. And you have the quotation, in fact, at paragraph 38 of our case. 38. Now, my lords, we say...
Sorry, did you say... Oh, yes, tab 110. Yes, 110. Sorry, yeah.
Page 43, F to G.
And where do we find the Dicey?
Dicey, my lady, is at volume 30.
Yes, I have that, the page reference.
295. The relevant page is at page 125. That's the heading.
And 128 as well, is it?
Yes. Yes, ma'am. 128. Just before the heading of habeas corpus. Now, my lords, my lady, the first point we make about the problem, as the Secretary of State sees it, the oversight sledgehammer problem, disproportionality, is that her department, the department, was advised when it adopted, when it applied, and when it persisted in the unlawful policy, that what it was doing rendered it vulnerable to challenge. That's Mr. Justice Davis at paragraph 43, page 73 of Appendix Part 1A. The department took the risk. We say with respect that it is asking the court now to let it off the hook, to use the vernacular, by changing the law.
But it's not an answer to the point of principle
The
to
point
say
of
that on the
principle-
facts of this case, the department took the risk.
The point of principle is that a power of executive detention is anathema to the common law. Generally, detention is decided upon by a court. That's the starting point. That is what explains the furore around derogating control orders in the aftermath of the Belmarsh case in early 2005. A court takes a decision detaining somebody, usually. It is exceptional to have executive powers of detention in our law. Now, the law doesn't require, we say, decisions to detain are correct. They simply have to be reasonable and lawful. But the law will insist that they are lawful. And where Parliament confers executive detention powers, it knows that the court will construe them strictly and narrowly. Mr. Beloff successfully persuaded the Privy Council of that proposition in Tanti Lam in 1996, relying on Lord Bridges' comments in Kawaja. And it will expect those powers that it has conferred to be lawfully exercised. And so we say that in the tort of false imprisonment, the defendant does indeed take the risk that what he is doing may be unlawful. It's what happened in the Evans case, even in a situation where the detention was judicially authorised. The governor was utterly blameless. He'd correctly fixed the release date pursuant to the law as it had been declared in the Gaffney and Norton case. My lord didn't want to be reminded of the line of case.
I mean, you say under judicial authority. The whole point about Evans is that it wasn't under judicial authority because the judicial authority ran out at a time before he was released.
If you apply the doctrine of retrospectivity and its progeny, the declaratory theory of law and it's the derivative principle of retrospective effect, yes. If you didn't have retrospectivity, then no, it was he was following a court order. He wasn't within the four corners of the court order, as my Lord Hope put it. He had to calculate the release date. He made an error because he followed the wrong law, which he was obliged to follow. But he bore the risk. He was detaining, he bore the risk. And we say there is a similar approach in the other trespassory torts as well. In the Entick and Carrington case, the Earl of Halifax bore the risk when he authorised his officers to enter John Entick's house and seize his property. So we say that the problem which the Secretary of State complains about, if I may put it in that way, has to be seen against how the common law views executive detention and illegality in relation to it. Can I then move on to the elements of the tort, my lords? And we address these at paragraphs 35 onwards in the tort, in our case. Now, can I ask one to just cast their eyes at paragraph 47, in fact, page 20. The tort, it is plain, is complete once the claimant demonstrates that the defendant directly, and we're happy to assume for present purposes intentionally, imprisoned him. We don't need to get into the complexities of negligent trespass and so forth. The burden then falls upon the defendant to show that he had lawful authority for doing so. Now, it doesn't suffice that the defendant had statutory authority. It doesn't suffice that the defendant complied with a statutory condition precedent, nor that he was within jurisdiction narrowly construed in a pre-anisminic sense. Least of all, that the defendant had a hypothesis for reconstructing the decision to detain. He has to show that he had actual lawful authority, not hypothesis. That authority may be impugned on public law grounds, and if that is done successfully, the authority is treated as though it did not exist in law. That is ultra vires, it's anisminic. There's no unscrambling problem here of the kind that you get when there is a time lag between the existence of an impugned act or subordinate legislation and its subsequent declaration as ultra vires. There's no problems in that regard. There are no policy imperatives that the Secretary of State can pray in aid. If the authority is impugned on public law grounds, it is a nullity. Anisminic was decided 3 years before the 1701 Act was enacted. It was firmly entrenched in our law when Lord Diplock decided Holgate Mohammed and Duke. He had given judgment in the Racal case, O'Reilly and Macman, and the National Federation case. And of course, it is deeply embedded in our law now. After Page in 1992, another case in which Mr. Beloff appeared, of course, and Boddington. And that is the orthodoxy. And finally, we say, since the claim lies as of right, and since there is no procedural exclusivity, at least not at the moment, Mr. Beloff suggests that there should be. So the action may be brought in the ordinary courts. Questions of discretionary remedies on judicial review don't arise, both as a matter of substance, because the claim lies as of right, and as a matter of procedure, because you can go before the ordinary courts who do not have prerogative powers and who don't have discretionary remedies of that kind, apt to quash a decision. They simply declare something as lawful or unlawful, or find something as lawful or unlawful, and if they do, then the public law decision is a nullity. My Lords may recall the remedy hearing and the remedy judgment in the Ahmed case. Once the court had found the orders to be ultra vires, that was it. The finding sufficed. There didn't need to be an order. And the Treasury's application for suspension, as my Lord Phillips put it, would obfuscate the effect of the Supreme Court's judgment in that case. The mere finding of unlawfulness sufficed.
So where is this case?
Ahmed is at tab 206, volume 21. And the remedy judgment is right at the back of the report. It was, by the way, it was the case which raised interesting issues of temporary invalidity and prospective invalidity, none of which was actually canvassed. My Lord Hope, I think, was with the Treasury.
This is the asset freezing.
It's the asset freezing case, yes.
So you're citing it for what proposition?
The proposition is that you don't need an order in order for something to be a nullity. A court finding that something is unlawful suffices. Fairly, I think it's a basic proposition.
I see.
Mr. Beloff and Mr. Beloff submits that as one of his solutions to the problem, that really people ought to be required to go for judicial review when they're bringing false imprisonment claims against a public official and get the detention authority quashed, because what that gets him is discretion. And we accept that in judicial review, a court may exceptionally refuse relief in exercise of discretion. But that's just not relevant where a claim lies as of right. That's the Winder case. Wandsworth and I'm probably mispronouncing it, Wandsworth and Winder, the case that was endorsed by this court a fortnight ago in Manchester and Pinnock. And so, my Lord, no question of discretion, we say. The better view, in fact, we would respectfully submit, citing my Lord Brown and Lord Bingham, is that when it comes to judicial review of executive detention, there is very limited, if indeed any room, for discretion at all.
Not presently ringing a bell. Where's this?
That's your Alba lecture, my Lord, in 1999, where
What about Lord Bingham? That sounds more promising.
that's another lecture, and that we've cited it at page 38, paragraph 98.
Of what?
So
Sorry.
what are we looking at?
Of our printed case, I'm so sorry.
What?
Our printed case.
Oh, your pretty case. Give it again.
Printed case, page 38, paragraph 98. That's Lord Bingham. And my Lord Brown, paragraph 100, page 39.
Well, yes, I'm not quite sure that that's saying what I thought you were saying it was saying. So,
We say
I mean,
the orthodox
that
view is-
begs the question in our case
Yes.
as to whether your client and all these others were unlawfully detained.
Yes, but we say what you don't do is judge that question by reference to whether or not a remedy on judicial review would have been given, where the remedy is discretionary. And you also don't judge that question by asking the no difference question. Would it have happened anyway? That's not the way the law approaches questions of errors of law, we say.
Say, on your submission, I'm just getting slightly lost. On your submission, does the fact, if it is a fact, that they would have been detained anyway, play any part at all?
On the question of liability, no.
No.
And there are many cases which establish that very clearly.
That's on that. And on damages,
Well, we say that we have a good case to say that you should not reduce the award, the basic award, but we say we have an unanswerable case, that you wouldn't reduce it in those circumstances to a nominal award only, because there is left the issue of a vindicatory award. Mr. Hickman suggesting to me I misunderstood the question.
No, I don't think you did, Mr.
I may have misunderstood him. But that's where that may be accommodated. But we say we have good grounds, given the nature of the tort, which I was going to move on to now, if I may. And we address this at paragraphs 35 of our printed case. We say that the purpose of false imprisonment as a tort in trespass is to protect rights rather than to compensate for harm. The focus of the tort is on the plaintiff's interest rather than the defendant's conduct. And that is conclusively demonstrated by the fact, we say, that the tort is actionable per se, even where the claimant is unaware of his confinement. This is because of the supreme importance the law attaches to the liberty of the subject. The supreme importance, that's the Murray case, Lord Griffiths, at volume 7, tab 71, 703A to B. My Lords, would my Lord like to see that? Sorry. This was a case where a suspect claimed damages for false imprisonment for a half-an-hour period between the time that the officers entered her home and the time that they arrested her. The court found in the result that they had good reason not to inform her of her arrest when they entered her premises. But for our purposes, what is important is the discussion at 701C through to 703B. Where Lord Griffiths preferred Lord Justice Atkin, as he then was, in the Mearing case, to a decision of the Court of Exchequer in Herring and Boyle. The foot of the page, 701H, it appears to me that a person could be imprisoned without his knowing it. He could be imprisoned while he is asleep, while he is in a state of drunkenness, while he is unconscious, and while he is a lunatic. You didn't need to be aware of it. You don't need to show damage. And that is, of course, what differentiates the tort from a tort such as negligence, where demonstration of damage is the gist of the action. as my Lord Hope put it in the Chester and Afsar case.
Lord Griffiths doesn't seem to support what you said in answer to my Lord Roger a moment ago on the question of nominal damages and vindicatory damages.
Yes. Mr. Westgate will address you in detail on that.
Yes.
He echoes something that my Lord Sir John Dyson said in a case called Langley, the child protection case. There are contrary views. Lord Justice Clark in the Roberts case in 1999. I think Mr. Westgate will develop, I'm sorry if I'm treading on his toes, but the idea of the vindicatory award gathers a momentum in cases like Ramanoop, Lord Nichols, and also the Ashley case, Lord Scott in particular. But, my Lord, if you don't need to show proof of damage, then it is not to the point that you would or would not have been detained. If, in fact, you were, and if, in fact, the basis of your detention was unlawful. The kind of causation analysis which is urged upon you by the Secretary of State, and which the Court of Appeal agreed with, only makes sense if you've got to show damage as part of a tort. This is absolutely basic, we respectfully submit, that you don't need to show that. Now, the second point that we make, this is at 41 of our case, is that the tort is one of strict liability. And that is revealing paragraph 42 because it demonstrates that the balance between competing claims on the law is struck very firmly in favour of liberty. As Lord Hope said, in the Evans case, at page 35, volume 11, I think it is, 11, tab 110, he said, the tort is one of strict liability that strikes the right balance between the liberty of the subject and the public interest. In that context, it was the detection and punishment of crime. And if we'll go to Christian Liczynski, if I may, very quickly, in due course, but if I can just cite to you what Lord Simmons said in Christian Liczynski, which is at volume 4, so Lord Simmons, Christian Liczynski, volume 4, tab 41, 595A, the liberty of the subject and the convenience of the police or any other executive authority are not to be weighed in the scales against each other. This case will have served a useful purpose if it enables your lordships once more to proclaim that a man is not to be deprived of his liberty except in due course and process of law. So no weighing in the scales of convenience of the executive authority and the individual. That's not the way the tort strikes the balance. You don't weigh the interests on a scale, and no deprivation of liberty except in due course and process of law. And that is why we say, I hope uncontroversially, that the trespassory torts, of which false imprisonment is, of course, a species, are rights-based rather than damage-based, in contrast to those which developed historically from the action on the case, such as nuisance negligence. Now, This aspect of our case, our focus on the historical origins of the tort and the way the tort balances competing interests, is addressed in one paragraph of Mr. Beloff's case at 7.9 of his printed case. And he says that our resort to ancient distinctions between actions in trespass and actions on the case, and to notions of different balances of competing interests, does nothing to further the merits of our approach. And then they say we cite my Lady Justice Hale, as she then was in the McLaughlin case, but that was an action brought in negligence, in which a causation test was applicable. The competing interests were nevertheless appropriately balanced, even though the loss stemmed from a loss of liberty. Now, that's all that's said about our submissions in this area. Now, the point that Mr. Beloff makes, if I may say so with great respect, about McLaughlin, is rather unfair, because at paragraph 44 of our printed case, we say that my lady made the observation she did in a different context, and in a footnote we say that this was a solicitor's negligence case. Our entire thesis on this area of our argument would be complete without that paragraph. But that's all that Mr. Beloff says about that whole section of our case. But the point goes deeper than that, because McLaughlin was indeed a negligence case. The argument was that the solicitor had breached her duty of care to the plaintiff client, in consequence of which he was convicted and imprisoned at trial, so it was a criminal case, I should say. And the interlocutory issue on appeal to the Court of Appeal was whether the claimant could recover for psychiatric injury. Now, one can speculate that an appropriate causation question perhaps could have arisen when the case went to trial, that the Court of Appeal allowed the claimant's appeal. And that question would have been, would the plaintiff anyway have been incarcerated in the hypothetical situation that there was no breach of the duty of care? Did the breach of the duty cause the loss? That would have been an appropriate causation question in negligence, where you have to show damage as an element of the tort. But imagine, my lords, if McLaughlin had been a trespass claim. Say the solicitor had locked the client in a room for a couple of days because he hadn't paid his legal fees. Could the solicitor argue that the loss of liberty wasn't actionable in tort because had the client attended the police station, he'd been remanded in custody anyway, or that he would have been incarcerated at trial in any way? Obviously not. And this is why the historical distinction between trespass and case, between false imprisonment and negligence, to which we refer, is important. The distinction is between direct injury to certain privileged interests that were thought to be especially detrimental to social well-being, hence, of course, the link between trespass and crime, and indirect injury. We say the trespass torts protect against direct interferences. That's the causation link. And there may be a difficult question on that issue, but there isn't one here. It could arise in the mental health context. If my lords, if my Lord Lord Brown and my Lady Hale, remember the Wilkinson case, and you have that at volume 4.
Well, if we're going to look at that,
sorry.
we'll do so too.
I wasn't going to take you to it, but sorry.